the matter. We have the
Mr.
instruction
Mujumdar,
matter.
learned advocate representing the petitioner on instructions would submit that the petitioner does not want to proceed with the instant application and writ petition. Having regard thereto, let the writ petition be dismissed
This is
as not pressed. Let a copy of the email communication as placed before this court by Mr. Mujumdar
yes.
Yes.
Mr. Ghosh is leading me. So application blood, I have already moved this application earlier, blood worship directed, we have served on them. But the fact is this blood, there was a contract awarded to my client by Purulia municipality for the house connections. 50% of the work was done. We placed the first running account bill because the tender item says this is without taxes and without GST. So we have put up the bill along with that saying that this is without prejudice for right for claiming GST separately. But what they're saying that bring deposit GST came to us, then we'll make you payment.
When was the contract? When did you receive the payment, Mr. Ghosh?
If your lordship comes to my bill itself, bill was placed on 6th of September 2024. That's at page 89.
So where is your? It's not your case that GST is not. It's GST.
GST is not payable.
GST is not payable.
Payable.
Not payable.
Not payable.
Why?
Without taxes. We will pay it and we'll claim it separately. But if your lordship looks into, kindly come to page 88.
To pay it means
Their tender says so. If your lordship kindly comes to page 88.
Page 18.
88. 88. Just prior page.
Yes.
That's the schedule of items. Your lordship get it also page 16. Same has been annexed twice.
Now, where is your exemption with regard to payment of GST?
Lordship, kindly come to this serial number, the chart, right hand side 1, 2, 3, 4, 5, 6 one.
Yes.
Number total amount without taxes.
Fair enough.
So the amount is without taxes. We have placed the bill without taxes.
That is your item rate BOQ.
Yes, that's their item. This is their item, this tender item, Lord.
Yes.
They have said so. I've only quoted about the items.
Yes.
Now what they are saying, will kindly come to the bill which were placed, Lord, page 90.
Yes.
That is the first 50% of the bill.
Yes.
1 crore and odd, Lord. Lord, should we get it at last page of this? That is at page 90. Next page.
Yes.
For rupees 1 crore 27 lakhs 19,107.
Yes.
Without prejudice claim for GST. That's a different issue. We'll claim GST separately. That's our bill. Now they will have to settle the bill. They will have to deduct if anything, if they want to deduct anything. This is a running account bill.
Against whom?
Lordship?
This is a cooperative matter.
No. This is a Purulia municipal matter, Malad.
Correct. This is not a group 4 matter. Oh.
No, Lord, the trouble is this, Lord. Trouble is that what they're doing it, had they clarified it, that will not charge it.
That I cannot decide.
No,
Whether you are liability to pay GST, I can tell you.
That's
yes, you are liable to pay GST.
Yes.
Having regard to the
That's
provisions
prayer I'm not
contained in the Act.
pressing. Lordship, kindly come to a prayer. That's the
Yes.
first prayer I'm pressing for.
Group 9 matter.
No. This will not go to group 9.
Yes.
Yeah, monetary claim. Prayer
No, it's not. Absolutely correct. But you are not doing that. You are not making payment.
Yes.
So kindly come to page 10, prayer A.
Yes.
That's the first RA bill we are claiming for. Part of the bill. 50% of work we have done. We are done. Now what they have done, Milord? They are not giving me site. They are not allowing me to execute work.
Deduct GST. It is not a TDS that you will deduct.
Correct.
Is it it is a TDS, Mr. Siddiqui? Deduction is not permissible.
But still, my lord, someone is liable to pay.
Correct. No, that question does not arise. That liability is very clear. Because since this issue is there of GST is there.
The municipality and the
Yes.
payer age of the return.
Forget prayer age. Are you entitled to deduct GST?
No.
Are you deducting?
Pay, my lord.
Pay
Is to be prayer age of the writ petition.
it off.
Interim injunction directing respondent to make payment of the admitted amount to the petitioner for the purpose of balance work in contract till disposal.
Yes. pay it off.
Why will I go into this? They are liable to make payment of GST.
To the authority.
Their
concerned.
bills ought to have included GST. Mr. Ghosh, your bills ought to have included
But
GST.
the-
It is
ten-
not a different issue that you have said that it is without GST. It cannot be. The
But the
court will not
taxes-
sanction that.
Yes, Lordship, the problem is
You,
this.
you may be having a contract which is an illegal contract. The court will not enforce that contract.
Absolutely.
Section
What we'll
23
have
of
to
the
do now,
Contract Act.
what we'll have to do now, after we receive the payment, we'll raise the invoice, deposit the amount with GST authority.
No, along with
Because
the
I'm
GST,
an enlisted,
you ought
I'm
to
a-
have raised the amount along with GST. Ought to
but
have done so.
that once we raise it, they will not make payment.
You cannot have the blessings of the court in the guise of this petition on enforcement of a contractual term which does not have the sanction of law.
But the difficulty is that they have prepared this.
And a
Now, what
contract
they're
down.
doing, even in,
Finish this matter. Mr. Siddiqui, you are there. You're not a party.
I'm for the state.
Yes, yes.
This
This
is all.
contract act. I'll finish it.
kindly look to section 31(4), subsection 4.
Yes, 31(4)
4
of the
বই
GST
পেয়ে
Act.
হবে? Yes,
Yes,
GST.
yes. একটা GST বই দাও ওখান থেকে। আর এখানে এই তো আছে। ওই তো, হ্যাঁ, ওটা দাও, ওটা দাও, ওটা দাও, ওটা দাও। Yes.
That's what, Lord. It's a continuous process. It's not that once I supplied the goods, chapter closes. It's a continuous
no.
process.
Can you say that it is without GST?
But
The parties could not have contracted to that effect.
this is a government contract. We have nothing to do.
What municipality is not government, Mr.
It's a government
Ghosh?
lordship. Article 12 is a government. Article 12 is a government lord.
Maybe.
We have to
It is a state within the meaning of Article
Yes.
12.
correctly, my lord.
It is not a
Now,
government within the
it-
Central Goods and Service Tax Act so that no GST will be
But
paid.
the moment we put our terms that it should be along with the GST, they will reject my tender. So we have nothing but to follow it.
That is
Now
entirely
kindly
up to
come to
you.
the subsection
The
4.
court cannot sanction this. The court will not sanction this.
No, but we deposit, kindly direct us to deposit GST.
Why will I
Authority
direct
concerned.
you? I will say that this contract, by operation of law, automatic having regard to the provisions contained in the Goods and Service Tax Act and the rules framed thereunder, you were obliged to raise bills along with GST.
Deposit. And they will pay it.
That I do not know whether it is.
But they will
internal
not make
contract
payment. My trouble will remain there. That's the problem, my lord. Because I'm otherwise cut for the head or cut for the tail.
That is entirely
That's the
up to you.
problem, my lord.
Because this court will not decide all your matters. If you have chosen to file this matter under as a group 4 matter and claim then what is the urgency today in the matter?
But what they have done now, they have stopped the work. They are not allowing me to
Neither
do
here
further work. Because site is to be given by them. So house connections, water
I'll
connections.
dispose it of Mr. Ghosh.
So kindly look to the section subsection 4 for my satisfaction.
Subsection
4,
of
31, section 31.
yes. What does it say? It says that you are not liable to pay
In
GST.
at what time? GST has to be paid. In case of
In
continuous,
terms of section 39, you are required to pay.
yes, right.
Returns.
Go to that. But kindly see 31(4) for a moment.
Yes.
At what time we have to pay it? In case of continuous supply of goods, where successive statements of accounts or successive payments are involved, the invoice shall be issued before or at the time of such statement is issued, or as the case may be, each such payment is received.
Correct.
The moment I'm receiving the payment, I'll have to raise this invoice, deposit this amount with the GST authority.
Where is your
They are not
GST
the authority to
bills?
receive it.
Where is your bills along with GST?
I cannot deposit, I cannot submit the bill with GST because GST, once I receive it, then I'll have to go to GST authority, then raise the invoice and deposit.
How
the
will you raise a separate invoice?
Because the
GST is based on that in Mr.
bill
Siddiqui.
is my
It
bill.
is based on the invoice itself.
No, but the difficulties, may
And
I
it
explain
is
to you, Lordship,
difficult to put it in the invoice.
but this is a construction work. So naturally, I have placed my bill. They will deduct here and there.
Construction work, Mr. Ghosh will not preclude you
No,
from.
but the
making payment
difficulty
of
is that
GST.
my bill is not the sacrosanct bill. They have the right to deduct something here and
They
there.
can deduct.
But they are not settling the bill, keeping it as
I
it is.
cannot go into that issue today.
That's they stopped the work on the curve of this. The GST has not been deposited by you earlier. That means I have to deposit the GST, pre-deposit it and come to them. That's where I'm objecting to that.
Your invoices ought to have included the GST.
But this is not the supply work. It's a construction work,
Construction
contractual
work
work.
does not require
But
GST.
because the bill says that I'll have to submit it without the taxes.
You are
So I've
not
submitted
rendering
it.
any service.
But correct
Are
me.
you not rendering any service?
Yes, I'm
So this is
liable to
goods
pay
and
GST.
services tax.
I'm
What is, let us come to
to
the
pay GST,
princi-
but not at this moment.
why not?
Well, after the bill is settled, payment is made, I'll have to go there immediately and deposit this amount with GST authority, not to them.
Revenue will wait when they will settle
No.
the bills.
Because unless they pay is the settle it, the amount is not really taking shape of it. It may be 1 crore 27, maybe 1 crore 17. So GST has to be calculated on the basis of the payment that's been made or the bill that's been settled. Now, the trouble is that, Lord, they will have to settle the amount. They are the service recipient. So naturally, Lord, unless they settle the amount, that this is the figure that I'm going to pay you. Deduct this amount, that amount, TDS, then cess, and many things they will deduct. Then the amount will take shape of it. But they are doing nothing. On the contrary, they stopped my work. No site, no directions. So that's the trouble being created, my lord.
Yes.
Now, my lord, kindly come to subsection 5 of section 31 also. But may place before lordship subject to the subsection B, my lord,
Yes.
where the due date of payment is not ascertainable from the contract. The invoice shall be issued before at the time when the supplier or service receives the payment.
Section.
Section 31, subsection 5,
Yes.
5B,
Yes.
where the due date of payment is not ascertainable from the contract. The invoice shall be issued before or at the time when the supplier of service receives the payment. When I will receive the payment, I'll raise the invoice, then
Unless
deposit
you
the amount.
receive the invoice, how the payment will come?
Correctly, my lord, unless they ascertain the amount,
Come to section
they
12.
will have to settle the
Mr.
amount.
Ghosh, come to section 12.
Section
12.
12.
What is the
Lordship?
time of supply of goods?
Yes.
Specifically indicated.
Yes.
Why this is not ascertainable? The liability to pay tax on goods shall arise at the time of supply as determined in accordance with the provisions of section.
Lordship.
Time of supply shall either be following dates: date on issue of the invoice by the supplier or the last date on which he is required under section 31 to issue invoice in respect of such supply,
Lordship.
or
But
the date on which supplier receives payment in respect of such supply.
the difficulty, may I tell you, Lordship, Lord, we kindly come to this.
You have received payment.
May I place for Lordship?
You have received payment.
No. The bill has not been ascertained at all.
You have not raised the bill along with the tax.
No, my lord, I have raised the bill as per the contract. I cannot raise the bill with the taxes. They will not accept it.
You want an observation from the court that this contract is
But
not
then my
executable?
payment will go
Absolutely.
away.
That is your choice. But
Then
I
my
cannot
payment will,
sanction this.
then I have to file a suit under section 65 of the
Whatever you
contract
are
act.
that,
Even
you
if
do
it's
that.
void, payment has to be made because they've enjoyed the payment.
Yes.
That will drag my client to another 10
I
years.
cannot help you here, Mr. Ghosh.
The water
I
supply
cannot
will
sanction
stop.
certain
Everything will
things.
stop. The emergency work will remain stopped. But let them
The
ascertain the
municipality cannot be permitted to contract out of the statute.
That's what they are doing.
Why have you accepted that?
But as
Why
an,
have you accepted that?
as an individual, can we fight with that? Because we'll have to do the work, we'll have to earn our livelihood also. If we do not submit according to them, they will reject my tender. Conditional tenders are not accepted.
Yes.
So section 12 also supports my case, my lord. I will receive
Section?
the 12 also,
Yes, show me.
subsection B, 12 to B.
Yes.
The date on which the supplier received the payment with respect
Correct.
to supply.
You
But
yes.
mine is not simplicity supply. It's a construction work.
Correct.
So
It's
they
a
will-
mixed supply.
They will
Those provisions are all there It does not absolve you from payment of tax, Mr.
No, I have
Ghosh.
never said so. I have never said so.
Liable to pay.
I'm registered, I will have to pay the money. Even if they do not make payment, I will have to pay the money. That's
Your
what they are now
liability
saying.
is always there. Even
But
if you
I'm not
say,
escaping my liability. But they are escaping their liability. They stopped my work. They kept me.
that is not for this court,
Court to go into
decide
that.
this. You
Correct.
make
You
up
have to
your
go
mind
pursue.
that if you want that prayer, I will release the matter. But if you want only an adjudication on this issue, then I will adjudicate this.
At this point, Lord, I'm only saying that because my bill is pending, they are saying that come up, deposit GST and come to us. That's where I'm objecting.
Deposit GST will not arise.
That's what they're saying to us.
And that declaration was
Clarifies it.
B. What is your prayer B? Let us understand
Well,
this.
prayer B, page 10, 11, sorry, Lord, page 11.
Prayer B you are not pressing prayer B? Are you?
Well, kindly be uncontrolled. Reach the nature mandamus, we should command response.
Where is the demand? Who has raised this demand?
But we're only for the prayer one.
No. You make
Yeah,
up your mind. If you don't, I cannot allow this prayer at all.
B, I'm not pressing that.
Alternatively, not to give effect to the demand from the petitioner. Where is the demand? I cannot grant any.
The difficulty is
No
this.
prayer of this nature can be granted. A, B cannot be granted.
No,
So-
A can be granted, B not.
A cannot and can be granted. Let us find out what is A.
A read in the nature of mandamus do issue commanding and directing the response.
Who is
No,
deducting the
or
no,
impose a
nobody's
demand.
case that they are deducting the TDS.
But they are saying that unless you pay
They are
the
not deducting TDS. So prayer A is infructuous.
can you clarify it?
Very
Can
well.
you
Now
clarify
come to
it?
C,
Lordship's
C,
order,
C.
my lord? That they are not doing it? That's what my learned friend is
And
saying.
what is the return the check? This cannot be granted in this jurisdiction.
No, my lord, I'm not
You
praying.
are not pressing
No,
C.
No.
D, you are not pressing.
No. C is production, certiorari. It's always there.
D is prohibition.
Then H, that's an interim order.
Ashu.
Lordship, can you clarify it so that they can also pay it out?
The instant writ petition has been filed inter alia praying for a direction upon the respondents not to deduct or impose demand of GST, not to demand
the
Affidavit of service filed in court is taken on record. Yes, next.
The issue
Yes.
is petition, my lord, is this. My lord, that order is passed. My lord, where
লিখে দিও এই in this order it will be corrected. আর তুমি শোনো, আপলোড না করে চলে যাও কেন? আমি রাত্রি বেলা
well, the issue in this petition is this, my lord, that a demand of 14 crore 82 lakhs has been raised upon me, levying penalty under section 74, my lord, for delayed filing of the return for 3 months, my lord. March 19, April 19, and May 19, my lord. That is the only ground, my lord. My lord, I am just coming to the facts. For delayed filing, my lord, the facts of the case is this, my lord, that for they have about 45 stores in West Bengal itself, and in other store. But the so-called notice is on page 77, my lord. Only yes, my lord. Yes, my lord. Page 104. Yes, my lord. Page 104, my lord. 104. Paragraph 10.2, my lord. This is the so-called notice. GSTR 1 was filed and says self-assessment for the month of March, April, and May in respect of Kolkata registration, and for the month of April 19 and May 19 in respect of Assam, Bihar, Tripura, Jharkhand, Odisha, and Andhra Pradesh registration was done after the intervention of the officer of DGGI KJU. West Bengal registration and so and the demarche in under section 74 of the CGST Act read with corresponding section of West Bengal GST Act and section 20. The demand is computed, whatever taxable, my lord, the liability which I have already paid. Then Assam, then Bihar, Tripura, Odisha, Jharkhand, Andhra Pradesh. Then, my lord, para 10.10, they refer to the so-called notice. And then, my lord, the GST liability is passed. My lord, that, my lord, kindly refer to the order, my lord, that would be more, my lord, precise. But that is the only ground, my lord, that my lord, kindly refer to page 79. Sorry, my lord, kindly refer to page 77. The case was initiated on the basis of intelligence gathered that Messrs. Bazaar Style Retail Limited has not filed GSTR 1 and 3B for the period March 19 to May 19 in respect of their Kolkata registration. On visit to the premises under such authorization under section 67(2), it was found that the taxpayer has failed to declare the liability in the GSTR 1 for the month of March, April, and May in respect of Kolkata registration, and for the month of April and May 19 in respect of Assam, Bihar, Tripura, Jharkhand, Odisha, and Andhra Pradesh registration, which was subsequently filed, and tax paid in their GSTR 3B returned after the investigation of the officers of the DGGI amounting to rupees 14 crore 82 lakh 67,004, which is also recoverable from the said taxpayer under section 74 of the Central Goods and Service Tax Act, as applicable along with the interest prescribed under section 50. The taxpayer is also liable for penal action in terms of 74 of the said act. Further, it was detected that is a different issue, my lord. Then, my lord, 1 second, sir, please let me complete my submission. Then, my lord, kindly refer to, sir, please allow me to complete for 5 minutes. My lord, kindly refer to order, my lord, page 58, my lord, operative part, page 58, order in original, from where it will be very clear, my lord, the precisely, my lord, why they have imposed. My lord, discussion and findings, page 58. This is order in original, my lord. No, my lord, I'm coming to that. Why? No, I am not preferred appeal. My lord, I have gone through the SCN, the statement recorded during investigation, the notices reply comes submission. I find that the following, page 58, my lord. 58, 58. Paragraph 16.2, my lord, I am reading out. Discussion and findings. I find that the following are the two main allegations which have been made in the above said notice. It has been alleged in the said notice that Mr. Bazaar Style Limited has failed to declare their tax liability in GSTR 1 and pay taxes by filing GSTR 3B for the month of April, March and May in respect of Kolkata registration, and for the month of April 19 and May 19 in respect of Assam, Bihar, Tripura, Jharkhand, Odisha and Andhra Pradesh. They have subsequently filed statutory GSTR 1 and paid tax by filing GSTR 3B return after the intervention of the officer. So their allegation is that only after they came to my premises that I filed. Had they not come, I would not have filed at all. The tax amounting to 1482.67 so paid from the said notice as per section 74 has been discharged without payment of interest under section 50 and penalty under section 74. Hence, interest as prescribed in 50 of the act and penalty in terms of 74, the act is recoverable from the notice. It has been alleged in the notice that the Bazaar styles have availed and that is another issue, my lord. Now, my lord, come to 16.6, my lord, 59, 16.6. I find that the submission of the said notice is very naive and ingenious, as huge volumes of transaction cannot justify delayed filing of returns. According to provision of section 37 of the CGST Act, read with 59 of the Rule 50. Yes, my lord. (16.2)(b). That is another issue, my lord. That is, my lord. That is, my lord. My lord, that in that issue, my lord, they have alleged that I have not. There is a violation of the section 16(2) subsection C, my lord, which says that if my supplier has not paid tax to the government, then I am not entitled to ITC. That is, my lord, part of another writ petition which is pending before your lordship, and item 55 of today's, my lord, the daily list, my lord. Because, my lord, there the constitutional validity part is involved. So that, my lord, that is, I am not, my lord, mix up the two issues which are not connected with each other. Yes, my lord. But that is with respect to only 97/23/216, my lord. My lord, I will argue that separately because that is in item 55. If your lordship wants to hear that, I can argue on that also. My lord, their allegation is, my lord, they have not conducted investigation. My lord, I don't want to argue on that, my lord. Kindly refer to paragraph 16.6, my lord. I find this submission of the said notice very naive and ingenious, as huge volume of transaction cannot justify delayed filing of return. According to provisions of section 37(1) of the CGST Act, read with rule 59 of the CGST rules, every normal registered person under GST is required to furnish the return in form GSTR 1 on month or quarterly basis. Form GSTR 1 broadly summarizes details of outward supplies of goods or services like taxable outward supplies made to registered person, taxable outward interstate supplies made to unregistered person, zero rated and deemed export, etc. The GST amounting to 1482.67,004 for the month of March, April 19 in respect of Kolkata registration, and for the month of April 19 in respect of Assam, Bihar, Tripura, Jharkhand, and Odisha and Andhra Pradesh registration was not declared to the department by not filing GSTR 1. Thus, the tax liability was deliberately not generated and informed to the department and kept undeclared while running the business, that is supplying taxable goods to a client during the period under consideration. Later, GSTR was filed subsequently after visit of the officer of DGGI KJU, though as per statute, filing of GSTR 1 precedes filing of 3B, to point out that first tax liability is declared, later payment of the said tax is paid. Here, the notices have not bothered to even declare that tax liability by way of filing GSTR 1. They could have declared their tax liability, then in due course discharge their tax liability. I am also of the opinion that had the officers of DGI KJU not launched this investigation, the evasion of GST would have remained undetected and non-declaration of that. My lord, no, my lord, prima facie. That is what I am trying to. That is what I am trying to say, my lord. My lord, the only broad issue which your lordship has to decide, my lord. No, not on merits. That is what I'm. No, on merits, my lord, I am not. My lord, I am. No, my lord. Yes, my lord. What, my lord, I am submitting is that delayed filing of return. My lord, the broad issue, my lord, which I am framing before your lordship is whether delayed filing of return for 3 months, my lord, whether it can tantamount to a willful evasion of tax, fraudulent intent, and intent to evade tax. My lord, that is the short issue, my lord, which your lordship has to decide. And my lord, I will show from my own record that not only for this month, for all months, my lord, from the day the GST, my lord, the inception of the GST, I have included it in my part of the petition. My lord, there have been delay of say 50 days, 60 days, 70 days, because my lord, to collect the data from say 45 stores in the state of West Bengal states and other, my lord, states also, and to file the return, that too at the inception of the, my lord, the very inception of the GST law. So, my lord, there was always a delay, not only for this month, my lord, there was always a delay. So, my lord, the question is, my lord, on the basis of the, my lord, there are several judgments of this Honorable High Court, my lord, the Supreme Court, that mere non-payment does not tantamount to, my lord, willful suppression or evasion or intent to evade tax. My lord, the onus of malafide lies on the shoulder of the department, that I have committed a malafide. When I'm running a store, my lord, all across, my lord, the country in 7 states, what is the reason for the officer to say? And when I've been regularly delayed filing return, my lord, I will just show from my record. My lord, kindly refer to page 140 onwards, my lord. Kindly, my lord. My lord, only to the extent, my lord, that whether delayed filing of the return can tantamount to willful suppression of fact, my lord. That is the short question, my lord. So, my lord, I wish to refer to, my lord, the judgment of Honorable Supreme Court in one case. But, well, kindly refer to page 14, my lord. This is the judgment. It starts at page 11. But this is a Supreme Court judgment. That very elaborately, my lord, after considering various Supreme Court judgments, the paragraph 12, my lord, page 14. We have heard both sides. Mr. R.P. Bhatt, learned senior counsel, appearing on behalf of the appellant, and Mr. Mikil Gupta, learned senior counsel, appearing on behalf of the revenue. We are not convinced by the reasoning of the tribunal. The conclusion that mere non-payment of duties is equivalent to collusion or willful statement or suppression of fact is, in our opinion, untenable. If that were to be true, we fail to understand which form of non-payment would amount to ordinary default. construing mere non-payment as any of the three categories contemplated by the proviso would leave no situation for which a limitation period of 6 months may apply. In our opinion, the main body of the section, in fact, contemplates ordinary default in payment of duties and leaves cases of collusion or willful statement or suppression of facts a smaller, specific, and more serious niche to the proviso. Therefore, something more must be shown to construe the acts of the appellant as fit to the applicability of the proviso. My lord, then they refer to the various Supreme Court judgments wherein, my lord, this particular principle of law has been discussed. I am not going into that, but kindly refer to paragraph, page 16, paragraph 24 only. We are not convinced with the finding of the tribunal, which placed the onus of providing evidence in support of bona fide conduct by observing that the appellates had not brought anything on record to prove their claim of bona fide conduct on the appellant. It is a cardinal postulate of law that burden of proving any form of malabite lies on the shoulders of the one alleging it. The court observed in so and so that it cannot be overlooked that the burden of establishing malafide is very heavy on the person who alleges it. The allegation of malafides are often more easily made than proved, and the very seriousness of such allegation demand proof of a high order of credibility. Then, my lord, kindly, my lord, come to section 73, my lord. Section 73, subsection 6. Subsection 5, my lord, first. Come to subsection 5. The person chargeable with tax may, before the service of notice under subsection 1, or as the case may be statement under subsection 3, pay the amount of tax along with the interest payable thereon under section 50 on the basis of his own ascertainment of such tax, or the tax is ascertained by the proper officer, and inform the proper officer in writing of such payment. The proper officer, on receipt of such information, shall not service any notice under subsection 1, or as the case may be under subsection 3, in respect of the tax so paid or any penalty payable under the provision of this act, all the rules made thereunder. So, my lord, once I have paid the tax and informed the officer, I am not like, my lord, I am coming to that. My lord, I am coming to that. No, my lord, kindly allow me to submit. My lord, kindly also refer to section 122. My lord, kindly, my lord, if there is a issue of jurisdiction, my lord, the issue of jurisdiction is whether section 74 applies in my case or not. But not only section 74, my lord. My lord, kindly also refer to section 122, my lord. Kindly refer to 122. 122 subsection 4, my lord. Where any taxable person who collects any tax in contravention of the provision of this act, but fails to pay the same to the government beyond a period of 3 months from the date on which such payment becomes due, then, my lord, what is the penalty to be levied? He shall be liable to pay a penalty of 10,000 rupees or an amount equivalent to tax evaded or tax not deducted or sought deducted or deducted but not paid to the government or not collected under section 52 or sought collected but not paid to the government. My lord, what I'm trying to submit is 122 subsection 4 refers to delay in payment of tax beyond 3 months, my lord. So if it is within 3 months, my lord, if it is within 3 months, then the penalty is not liable to be levied. Only if it goes beyond 3 months delay in payment. In my case, my lord, in all the cases, the fact of the matter is that the payment is not beyond 3 months, my lord. Within 3 months, my lord, it is not, my lord, for the month of March, my lord, there was a finalization accounts to take place. The finalization of accounts took some time. मतलब yes, yes, correct. Yes, 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 madam. मतलब section 122 says that if there is a delay, no, my lord, it says that if there is a delay beyond 3 months only, then the penal provision is attracted. My lord, here they have, my lord, section, my lord, it is without jurisdiction because section 74 could not have been applied in this particular case. My lord, there are two, one judgment of the honorable, my lord, one judgment of honorable Karnataka High Court in the previous regime, my lord, with respect to delayed filing only, my lord, I will refer to. My lord, I am reading out from paragraph 2. Facts are not in dispute. The SSC has paid both the service tax and interest for delayed payment before issue of so-called notice under the Act. Subsection 3 of 73 of the Act categorically states that after the payment of service tax and interest is made and the said information is furnished to the authorities, then the authorities shall not serve any notice in respect to the amounts of paid. Therefore, authorities have no authority to initiate proceeding for recovery of penalty under section 76 of the Act. Unfortunately, the assessing authority as well as the operator seems to think if an SSC does not pay the tax within the stipulated time and regularly pays tax after the due date with interest, it is something which is not pardonable in law. Though law does not say so, authorities working under the law seems to think otherwise, and thus they are wasting their valuable time in proceeding against the person who are paying tax, service tax with interest promptly. They are paid salary to act in accordance with law and to initiate proceeding against defaulters who have not paid service tax and interest in spite of service of notice calling upon them to make payment, and certainly not to harass and initiate proceedings against persons who are paying tax with interest for delayed payment. It is high time the authority will change their attitude towards this taxpayer, understanding the object for which this enactment is passed, and also keep in mind the express provision as contained in subsection 3 of 73. The Parliament has expressly stated that against person who have paid tax with interest, no notice shall be served. If the notices are issued contrary to the said section, the person to be punished is the person who has issued notice and not the person to whom it is issued. We take that in ignorance of law, the authorities are indulging in extravaganza and wasting their precious time and also the time of tribunal in this court. It is high time that the authorities shall issue appropriate direction to see that such taxpayers are not harassed. If such instances are noticed by this court hereafter, certainly it will be a case for taking proper against those lawbreakers. Then, my lord, kindly refer to one judgment of the honorable. My lord, one judgment, my lord, only of the Supreme Court with respect to interpretation of one paragraph, my lord, for interpretation of penal provision.
The show cause is consisting of two parts. The show cause was issued on 30/9/2022, which is at page 77. There are two parts in the said show cause. One is for fraud, my lord, taking the ITC in an illegal manner by showing that they have availed it from the suppliers and from the stockists, page 77. From the suppliers who are non-existent, through the vehicles, the existence of vehicles are in question. They have availed ITC. For that, the show cause is there. That is one part of the show cause. Yes. Lordship kindly comes to page 78, para 2.2. And the other part is the, yes, 78, para 2.2. Further, it was detected by the officers of DGGI KZU. It was found that Messrs. Lavender Enterprises, Messrs. Unique Exim, Messrs. Fortune Exim, Impex, Planet Traders, were non-existent at their place of business and Panchnama was drawn at the business premises of these entities on 29/8/1919. Alert notice in and the second part is, Malad, the first part is very elaborate and the show cause entire detail has been given. And the second part is non-filing of the return within the time for which they are liable to pay the tax as well as penalty or interest, which is at page.
It was 3 years after this, my lord, filing of the return. They
Or we have short for the extended period of limitation. Thereafter, the show cause has been issued. Now, Lordship, kindly come once comes to page. Yes, only once, Lordship. Or we investigated whether they were paying taxes or not, whether they were availing ITC in the proper manner or not. The investigation has clearly shown that they have availed ITC in a total illegal manner. First of all, the stockages were not existent, and so far the delay payment and so far the filing of the returns are concerned, they have made so only after the investigation has started, only after they were knocked by the officers. Thereafter, they have turned around and filed the returns. Now, yes. This is definite finding to that effect. Yes. Roshi kindly comes to page 60, para 16.8. 60. Yes, it is there in the show cause also. The extended period of limitation has been taken in the show cause at page 102, para 9. Para 9, invoking the extended period of limitation at page 102.
In both the
That
counts, my
apart,
lord.
that apart, Lordship.
Paragraph 9.2 refers to the delayed filing of the return, my lord. The invocation of the extended
apart.
period of limitation
That
for
apart,
delayed
Lordship,
filing
kindly
of the
comes to
return.
page 59 once. Page
Paragraph
59.
9.2, my lord.
Paragraph 16.6.
9.2 is for delayed filing of return, my lord. For they say that had they not launched the investigation, I would not have filed the return at all. And therefore, extended period is invocable. The investigation was done in, my lord, March 19. Thereafter, they have waited till 3 years to issue me a so cause notice. When they were very well aware, and my lord, I kindly referred. Yes, my lord. I have paid everything. No, my lord, kindly refer to page 140 for once. Kindly refer to page 140. 140, my lord.
Now, Lordship, there are other.
One second. Page 140, my lord.
Page?
140, 140. But no, my lord, not married, my lord. My lord, whether extended period of limitation could have been invoked, my lord, there is a my lord, that is a issue of jurisdiction, my lord. My lord, kindly refer to 144 once, my lord. My lord, kindly refer to 144 once.
Page. I will
140, my lord, kindly see. Regularly, my lord, I have been filing delayed filing return. But why only these 3 months are picked up? My lord, I fail to understand. Thereafter also I have delayed, but there is a delay in filing. After, my lord, May also, there is a delay. Prior to that also, there are consistent delay, my lord, at my end. So if I have been consistent in delay, then what is the ground to say that for this month, had you, I would have not come, you would not have filed the return. My lord, kindly refer to page 140.
Now, Lordship, kindly comes.
No, my lord, they have to show some ground, my lord, that I was in the verge of shutting down my business. My lord, I have referred to the Univer textile judgment that the burden of proving malafide is on the shoulders of the one who alleges it. My lord, the question is they made. No, my lord. No, no, my lord. No, no, my lord. Why I'm stating, my lord, that why the burden does not, my lord, why the burden shifts to them. My lord, I have explained my reason for the delay. No, no, my lord. No, my lord. No, my lord.
Availment of ITC.
But that is, my lord, I have already filed 2 writ petition, my lord.
Or he cannot dissect the points. He's challenging the order in toto.
No, my lord, kindly consider, my lord. My lord, kindly consider. My lord, no, my lord, kindly allow me to submit. No, my lord, kindly allow me to submit, my lord, for 2 minutes. No, on merits, not on merits, my lord. Only 2 minutes on jurisdiction, my lord. My lord, they have invoked extended period of limitation for, my lord, this delayed in filing of the return also. My lord, whether the extended period of could have been invoked is an issue of jurisdiction, my lord, which your lordship can decide. My lord, whether delayed filing of return, extended period of could have been invoked is an issue of limitation, my lord. On that point, my lord, there is a judgment of, my lord.
Or before that,
my lord,
my lord.
No, my lord, that is another issue, my lord, of constitutional validity.
And he has not challenged the show cause itself. He has not challenged the show cause
no, my lord.
itself. Only the order. Only the
My
order.
lord, once the show
Yes.
cause has
Lordship kindly
culminated
comes to
into
page
order,
23.
then, my
Lordship
lord,
kindly comes to page 20
challenging the order means challenging the show
22.
cause notice.
The petitioner
What is the need
challenged
to
the order
challenge the
only.
show cause notice when I have challenged the order? I have been consistently delayed. There has been a delay in filing of the return. There are 45 stores across West Bengal itself, and there are other stores. Have they come to any finding that I had shut down my entire business, my head office, everything I have shut down? I am a listed company. Whether I have got myself delisted and I'm on the verge of shutting down my business to go out of the business and not file their return or pay their taxes. That is why I'm saying, my lord, kindly refer to page 140. There is a consistent delay on my part, my lord, on filing of the return.
No interest paid ever.
Consistently delay, my lord.
No
It is
interest
not
paid ever.
no, my lord, no interest is paid, my lord. And my lord, one more point. There is a consistently, my lord, balance in the electronic credit ledger, my lord. There is a consistently, my lord. I have referred not on merit, my lord, or this on point of jurisdiction, whether 74 is invocable, my lord, at all. My lord, if the 74 is not invocable, my lord, then it is a issue of jurisdiction, my lord. 4th May. So kindly allow, kindly allow 1 month time, my lord, if your lordship can allow from the date. Yes, my lord. But the date of filing, my lord, was 3rd of, my lord, March it was filed. 3rd March. Grateful. Grateful, man. Grateful. Grateful.
Grateful, sir.
My lords, I have filed this writ petition. This is due to the inaction on part of the customs authority, my lords, to allow my goods to be exported, my lords. May I briefly state the facts, my lords? I am a 100% export-oriented units, my lords. I manufacture powdered cinnamon, powdered areca nuts, and powdered clove nuts, nutmeg powder, my lords. On 7th of January, my lords, I filed my shipping bill for export of powdered areca nuts, my lords. My lords, on powdered areca nuts, my lords. Powdered areca nuts. My lords, I was supposed to export. I filed a shipping bill on the 7th of January, my lords. On the 10th of January, I'm given to understand that my goods have gone for examination by the customs authority, my lords. Till date, my lords, the customs authority have not communicated to us.
The goods were found to be containing wood powder also along with other ingredients. The goods were found to be containing wood powder along with other ingredients. Wood powder. And we have collected the samples. We have sent it for testing on multiple times. My lord, we are awaiting the result. In the meantime, my lord, we are also seeing to their prayer for provisional release of the goods. So, if your lordship kindly gives us some more time, we can give to your lordship the result as to their application for provisional release, whether that has been allowed or not.
Minutes.
Yes. Very.
Yes, my lords. That is my first, my lords. I have a second cause also, my lords. Yes. Yes, my lords. Much obliged. Affidavit may be kept on record. Much obliged.
In alternative, may I just say in this way, my lord, they have made an application which is at page 50 for provisional release. No, in the meantime, if the authority concerned takes a decision within 2 weeks' time.
Millards, one small point, Millards. In the Millards, due to this goods being kept at the port, Millards, I'm incurring huge demurrage charges and detention charges, Millards, which is the law permits the principal commissioner or the commissioner to waive these charges, Millards. At least, Millards, till that extent, these charges might be kept in abeyance till the next date of hearing, Millards, because the commissioner of customs has the power to waive these charges by the port authorities and the container and detention, demurrage and detention charges. Much okay.
Or let the representations be considered by the concerned respondent. Instead of respondent, concerned respondent.
Much obliged.
Grateful to your lordship.
I am for petitioner.
Dago.
If it pleases, my lord. I am for the petitioner, my lord. My learned senior, Mr. Bagadia, my lord, is for one of the pro forma respondents, my lord, in this matter. And my learned senior's individual matter, which is analogous, is also running in my lord's monthly list.
I can address my lord, or I can supplement him as my lord comments, my lord.
So for a separate monthly list matter, I'm not taking up.
My lord, this matter only my lords will take, nothing else.
Yes.
Everything is there with
Or
us.
you want this matter to
Yes,
be
yes.
tagged along with that matter? So I will tag it there.
My lord will hear this matter, whatever happens here will happen there also. Nothing different,
Continue.
my lord. My lord, we are basically, my lord, challenging the rejection of a request for common adjudication. Common adjudication. My lord,
Challenging rejection of a request or allowing of a request.
rejection. Rejection. My lord, I will show, my lord, this is the third round. 2 rounds before our High Court, my lord, I will show that identical issues are involved. The courts have held and it has proceeded accordingly. And that is why, my lord, it is imperative that this order be a common adjudicating authority may be appointed to adjudicate these issues. Because here is a, my lord, case, I'm not going into the merits. It is a case where the assessees are sandwiched between the state and the center. It is a case relating to service tax. We offer services to KMC. KMC says we are not liable to pay. Center says you are liable to pay. But not on the merits. And I will kindly see the impugned order at page 37. 37 capital A is the typed copy. My lord will kindly take 37 capital A. This is the impugned order which has rejected my request for a common adjudication, common adjudicating authority. There are 3 assessees.
Yes.
There's 1-page order, my lord, may I read, man?
Yes.
This bears reference to your letter dated so and so with regard to the appointment of common adjudicating authority for consolidation of adjudication process under one adjudicating authority in respect of show cause notice bearing come demand notice dated so and so issued in compliance of the common judgment and order dated 11th July 2022 passed by the Honorable Calcutta High Court.
Where is that order?
My lord, I'll take my lords to this order. I'll take this. Your request has been duly considered by the competent authority in the light of the extent legal provisions applicable in the facts and the circumstances of the case. In this matter, I have been directed to inform you that since the division bench of the Honorable Calcutta High Court has remanded the matter to the original adjudicating authority for fresh decision, by order dated 30th April 2024, it has to be abided in letter and spirit. Hence, there is no scope of appointment of a common adjudicating authority as requested, since non-compliance of the Honorable Court's order would tantamount to contempt of court. Further, the erstwhile service tax statutes have no legal provisions whereby Principal Commissioner, Chief Commissioner has been vested with the powers to appoint common adjudicating adjudicator. My lord, this is a third round. I'll take my lords. My lord will kindly come to page 43. But this is the first order of the learned single judge trial court whereby the writ petitions were dismissed. And at page 43 is the first order in respect of one assessee. My lord will kindly see page 48 is respect to the second assessee. And at page 52 with respect to the third assessee, all same orders on the same date. But against this, the assessees filed appeal to the division bench. My lord will kindly see this order, which is referred in the impugned order also at page 56. This is the 11th July 2022 order, which has been referred in the impugned order, which we just read, my lord.
Yes.
At page 56 is the division bench order. All the 3 writ petitions have been taken up together. My lord will kindly see para 5 at page 58.
Yes.
My lord, it says that since issues involved in these 3 appeals are identical, with the consent of the learned advocates appearing on either sides, the appeals are taken up for hearing together. Then, my lord, pursuant to this order, matters were remanded and show cause notice was again issued to each and every assessee. It was again adjudicated. Again, we came back to this honorable court. My lord, in the writ jurisdiction in the trial court, my lord will kindly see page 83.
Yes,
82 is dismissal.
Yes, but matters, my lord will kindly see in the first paragraph, they note, the trial court notes this, my lord, page 79, my lord, will kindly take page 79.
It
Sorry.
is the division bench order.
No, 79 is a single bench order
Yes.
dismissing my writ petition,
On the ground of alternative remedy.
my lord. But my lord will kindly note page 79, all three writ petitions are listed and taken up together.
Yes, what difference does that make?
But I'm trying to only show that all throughout before this High Court, my lord,
Arya, point is not that. High Court may be hearing several points matters together. What cause of action do you have
my lord.
to have a common adjudicator in these cases?
My lord, this is the reason, my lord, because the High Court in the entire always has taken up these three matters together.
No,
It has said that the identical issues are involved. My lord will kindly appreciate what happens. My lord, identical legal issues are involved. Issue in just in a nutshell is that I offer services to KMC. KMC issued a circular saying that service tax is not payable for services rendered by me and rendered to me also. And
for a particular period.
after that circular period, before that they were paying service tax. We were raising invoices on KMC.
Mr. Arya,
My-
I want to ascertain, please actually correct me, then
My lord, my
unless that is very difficult.
My lord.
Different show cause notices for different periods.
yes, yes.
Only different periods.
Yeah,
Only
overlapping
different
periods are there.
Only period.
The overlapping periods are there, but from
I want to know from you. Only period. Does not matter, but it is the only period. Otherwise, issue is absolutely identical. Multiplicity of proceedings. It will give rise to different opinions. You see, it is in your interest you should do this. It will give rise to today, one person says while deciding accepts his contention on a particular point and rejects the others. The other person says, no, just a minute, I'll hear you. He accepts it on a different contention. So by this process, he will be successful in evading the entire liability. He might be, I'm not saying, he might be. It is in your interest, you take instruction. See, one adjudicator, High Court did not say while remanding the matter, there is neither, High Court remanded the matter to the adjudicator. Whether or not you will appoint one adjudicator or different other. Correct. So there is no difficulty in taking, you take a decision, I'll make an order of court. And if it is not there also, but it does not interfere with the order passed by the division. Does not. The division means remanded the matter. Correct. Now he says that since the issues are similar, forget his reference to those orders. I am not going to. That this is not a point of joining issue on anyone. It is a question whether if all the parties are together, what is the effect thereof?
Yes,
Before one person. Correct. If he has not done it, bad.
At this point of time.
What wrong now say one adjudicator decides in his favor, the other against him. No.
These are all separate parties. KMC is not adjudicating. It is only the assessee wants a common.
Assessees are separate.
Yeah, assessees are separate, man. Three assessees are there. Only three assessees. No, all three assessees are same during the.
Assessees are separate.
The assessees are
What
separate.
is
All
this going
three.
on, sir?
Yes. Obviously, assessees.
Why one as an adjudicator? They are separate assessees. No. No, you could prefer a High Court decided the issue remained for what was there in the appeal. First matter. High Court decided that on the ground of alternative remedy. What was the issue involved? Whether the alternative remedy was there, what is the alternative remedy barred filing of not barred, whether by reasons of the alternative remedy the petition was not made. That was the issue. Nothing to do with the adjudication order. No. That was not considered, rejected. Rejected. So what was the direction passed by the division bench? Yes.
No, we'll go to the last order of the division bench. My lord will kindly come to page 86.
Complete your submissions. Yes.
My lord, page 86.
Hmm.
All three parties are named. All three parties' writ appeals are mentioned.
Page 79.
86.
79 is the order starts. No. First round, where is the order passed by the DB?
First round DB order, my lord.
Yes.
My lord, first round DB order is at page 56.
What does the DB do?
My lord, it makes KMC the party and remands the matter. My lord will kindly take page 56 at we will kindly take page 61, para 9 onwards. Now, KMC has taken a stand. At page 62, thus, unless and until the adjudication is done in the presence of KMC, it will not be a binding adjudication. KMC has to be made a party to the proceedings and is made a co-noticee along with the appellants. And thereafter, an adjudication has to be commenced. And after hearing the parties, a speaking order is required to be passed. After this order, my lord, they re-adjudicated after issuing fresh show cause notice as per the direction of the Honorable Court and made KMC a party. What is that? No. Just on the last after this judgment, my lord, when the re-adjudication was done, it was done by one person in respect of all three assessees separately. Only one person has adjudicated. We are carrying the first page and the last page of those orders. That was again challenged before the second round, before the Honorable Court. Then, my lord, the second DB's order, my lord will kindly come. Page 86, it starts. My lord, all three writ appeals are taken up together.
Where is the second? Where is the decision on the first pursuant to the first DB order?
But decision is not annexed. It's a bulky decision order in original, which we had challenged.
Common order.
No, not a common order. Separate orders by the same authority. Same gentleman, my lord. We are carrying the same first page and the last.
By the same authority.
Same gentleman, my lord. Three separate orders. Three separate
Same
orders.
gentleman, same authority.
Same gentleman. Three separate orders. Yes. That I'm saying. Three separate show cause notices. Three separate orders by the same gentleman. Ashish Chandan. In all three matters.
Yes.
Then, my lord, before the DB, my lord, at page 87, first paragraph, first line, my lord will kindly see.
Yes.
This is the second time the three assessees are before this court on the same issue. My lord will kindly mark.
I don't know what self-same issue. We have to read out. By marking will not do. What was the issue involved in this appeal?
Same, my lord.
Why?
Yes, my-
How can it be same? You did not show me the trial court's order. Issue was arising out of the order passed by the trial court.
My lord. My lord.
So where is the order by the trial court?
The trial court's order is at page 79.
Show me that. 79, what is that? 79 is dismissal on account of alternative remedy.
My lord.
So what was the issue? Alternative remedy was the issue, Mr. Bagadia.
Well, alternative, it was
Absolutely.
no, it was not the issue. It was dismissed on that ground.
So
But
that
that is
was
not the
the
issue in the
challenge.
writ petition.
Mr. Bagadia, that was challenging for the High Court. Issue was
Yes,
that.
yes. So, but DB upheld the assessee's contentions.
So that was challenged.
Yes, on natural
That
justice.
was the issue involved in the writ petitions.
So, issue was multiple, my lord.
Not writ petitions in the appellate before the appellate authority, the appellate court division bench.
Yes, it succeeded. Assessee succeeded.
Yes.
Assessee succeeded before the DB, my lord. My lord will kindly see the observations at page 92, para 11 to 13.
Yes.
For the above reasons, the appeals are allowed. The orders in originals dated so and so are set aside, and the matters are remanded back to the adjudicating authority. The adjudicating authority for fresh consideration. The adjudicating authority. My lord, here always the court is now recognizing the adjudicating authority. In the first round, my learned friend had
Don't read it as a statute.
no, my lord. In the first round, my learned friend pointed out they had said the concerned authority, but out here it has become the authority. They are not saying concerned authority. In the first round, the DB said concerned authority. In the second round, they are saying the adjudicating authority. There's a difference, my lord. And my lord, having not going so much into the details of the language, my lord, the impugned order has rejected on two grounds, saying that they will be in contempt of the court's order. This I am objecting. Second, my lord, they are saying that they do not have the powers under the service tax regime. I'll place the board circular to show that they have the powers.
Show me.
My lord. My lord, one circular is already attached. My lord, 2015, page 125. My lord will kindly see at page 150. That running page 151, my lord will come. It starts at the bottom of page 150. Issue. The issue regarding competence of the chief commissioner and commissioner for to reassign cases for adjudication among different commissionerates were discussed. Discussion and decision. After discussion of the legal provisions and delegated powers with the chief commissioner, it was concluded that, my lord will kindly see II, in exercise of the powers of the board delegated to the chief commissioner by notification number 11 by 2007, chief commissioner may assign cases from one commissioner to another for expeditious adjudication when pendency is large and such reassignment is necessary. Similarly, the chief commissioner may reassign cases for levels below the commissioner from one commissioner to another within his zone. Appropriate orders would be required to be issued for such reassignment of cases. Chief commissioner can also issue orders appointing common adjudicating authority within his zone. This is a 2015 circular, my lord. Even in 2017, the same circular, my lord, same stand.
Yes, Mr. Manager.
इसमें कौन सा पैरा?
What is your contention? Make out your. He has made his contention.
Not to the competence of the chief commissioner. That's what he assigned him. But over here, the chief commissioner wanted to kindly see the order of the insurance first. Kindly see page 63. Paragraph number 10. In the result, the three appeals are disposed of by this common judgment by directing the concerned service tax commissioner to issue fresh so-called notices to applicants as well as KMC. And after hearing the parties, the concerned authority shall adjudicate the issue and pass a decision on the merits in accordance with law. Thereafter, in paragraph number 11, fourth line, And we have not decided the legal issue which is open to be decided by the concerned adjudicating authority. The concern of adjudicating authority can issue so-called notices to the applicants as well as the KMC within a period of 4 weeks from the date of server copy. And the KMC are granted 4 weeks. Thereafter, the adjudication process shall be commenced and completed within a period of 3 months. The authorized representatives of the applicants and the KMC shall be afforded an opportunity parties are directed to cooperate with the concerned officer for the early conclusion of the adjudication proceedings. So it is not, it is restricted to the concerned adjudicating authority with the decision made by its own wisdom has decided the issue that the KMC ought to be heard, OAMC and the petitioners are all to be heard by the concerned authority. Now, on the second issue, kindly see the order of the division bench.
Is it your case that the same person adjudicated? After this, same person adjudicated.
What here the
Is it your case the same person adjudicated?
same person?
Adjudicated.
Now, the
Adjudicated.
hearing has been done by the different commissioner.
Pursuant to the order passed by the revision bench, which you just showed me on
No, two orders in the
on
first
11 July 2022.
2022.
On 11 July 2022, was it done by the common authority?
The same person holding different charges.
A person holding different hats.
It's the concerned officer was holding charge of both the commissioner. Is the principal commissioner. One is for South, and one for.
Same person.
By that reason, the same person has passed an order. Now the commissioner and such have been reconstituted and separate officers are there to see. Now, if I discuss with sufficient premises right for hearing, whether they should have ought to have taken this point at the time of the first instance or at the second instance. That
How many days had passed?
how
How many hearing was done?
they have sought for right subject to correction. Color page 1.
Once. Page 96.
My lord, our application is annex, my lord. At page 97. Which is rejected by the impugned order.
Page 107. Is there even proposition?
Yes, the application is at page 97. Now, this was rejected by the impugned order.
Dated? Order dated?
The impugned order is dated 5th February 2025.
Where do I get it? It's yes.
And my lord, thereafter we were given personal hearing notice in this matter because of which urgency was mentioned, my lord. Personal hearing notice is at page 152. The other two assessees who are running in the monthly list, they haven't received personal hearing notices, so we did not mention for urgency in those matters. Here we had received personal hearing notice, that is why urgency was mentioned. Page 152.
No, that is all right.
Yes, madam.
When was the first hearing take place? When did the first hearing take place?
No, we haven't participated in the hearing. We did. Page 96. 96, my lord, we gave our demo.
First hearing when?
First,
Yes, yes. Mr. Mujumdar, first hearing when?
18?
Before the division bench order. Before the division bench order, we are not concerned. We are also not concerned with regard to that. It is the second stage after the second DB order. Second DB order, we are required to file a show cause notice.
After second DB order,
No, no.
after first. The show cause notice was issued after first DB order.
Correct, I have seen that. Second DB order is dated when?
No, second, no, April 30th.
April 30th, which was subsidiary corrected on 5th of May,
My lord,
10th of May.
my lord.
Now, after that, any hearing took place? When?
Then we sought adjournment.
So, only hearing took place in November.
Then we sought adjournment at page 96.
They have given a letter in December 2024.
Yes, after.
Anything else?
At page 96, they plead for time.
Yes.
Page 96. On the common adjudication of on the society respective submission, division benches as they are gone. Single benches when they get there. Thereafter, the division bench started regarding the matter of legal issues. On the merits, we have nothing to say. But with regard to the common adjudicating authority, matter in my respective submission, that ought to have been agitated or stated or submitted by the division bench or the first instance or before the second instance. Now, when it is going to be going to write as per the order of the division bench, now a question of adjudicating authority. Trusted the entire purpose of expediting.
Now, how many hearings has taken place? You have to give him personal hearing, otherwise you cannot dispose it off. I'll fix it. I will fix a particular date. You complete it with a common person on that particular date. Why? What is your difficulty?
Common person is trusted the entire purpose because
Why?
it is from the different commissioners. Their service files are from or the SSC's files. First 3 persons are different. They may be having a common further action with regard to the KMC and the manner of service tax payment. That the commissioners are competent enough to handle the situation. Now, every person will catch hold of 100 other SSCs that, sir, my issues are different. My cause of actions are same. So kindly appoint 100 my adjudicating authority in respect of my issue, which is similar. The amount is also not the same, subject to correction. Although it will create a incident which we will not be able to handle at a later point. Why it is they are emptying the cart before the horse all the time? Is there any problem with the adjudicating authority that someone is not listening to them?
We have never.
Also has to consider that saying that all the facts is same all the 3 cannot.
Yes.
No, on rebuttal, my lord, couple of things. My lord, if my lord will kindly see the case history, my lord, KMC was never a party to the original proceedings. KMC was later on made a party in the first round. Thereafter, my lord, in the second round also, the division bench, we had succeeded in convincing the division bench that the natural justice was being violated. But taking into account these factors, if a common adjudicating authority is appointed, it will cause prejudice to nobody. No, it's not a mandate. You have the power. They have rejected saying that I do not have the power. There's no ego. It is whether it causes prejudice or not.
There is any conflict of issues that can.
Why is the department taking such a strict stand that it cannot have
What
it?
is the first petition? Sheikh Jalal's petition? First one in.
This one.
No. The first order. Sheikh Jalal did not file a writ petition.
Yes.
Where is that order?
The first division bench order.
Single bench order.
Page 48. Just as 38.
At page 40.
No, page 43.
38.
Page 43. Page 43.
That is Bengal Protective.
Yes, but this is sole proprietorship.
questioning the
But this matter will again come back because the circular will be challenged by the
আমাদের copy, read petition.
ওর মধ্যে ফেরত দিও না।
my senior had done one matter. Puneet Dhanapal. Puneet Dhanapal. I have the total.
একটা করে পাঠাও না তুমি তো।
ওইটা আমাদের।
ওইখানে শুধু
Chaudhary was there.
বিপুল নামটা যাবে, হ্যাঁ, বিপুল নামটা যাবে। আর ওখানে বোধহয় ওর নাম যাবে। Oh, you are common in all. Mr. Kundolia's name and Mr. Banerjee's name will be, Mr. Bhanjo is also common in all. You are also common in all. Mr. Singh's name is also common in all. Union of India. আছে তো পেয়ে তাহলে এটা রাখো, কালকে ফেরত দিয়ে দাও না, তোমার কাছে আছে নাম্বার গুলো টুকে না।
My lord, in the body of the order, my lord has referred to Mr. Banerjee. Instead of that,
Yes, and I'll put in that particular paragraph also. এই ওই প্যারাগ্রাফটা রেখে দেবে 59, ওটাতে আলাদা আলাদা অর্ডার আলাদা আলাদা চেঞ্জ হবে।
there's para 3 of the September orders that will, my
Yes,
lord,
I've seen that.
para 3.
For the next matter,
I'm grateful, my lord.
Grateful.
Number 7.
Sorry, take it fully. May it please my lord. Lords, though this is a case under 129 subclause 3, Lord, the order of detention and final order of penalty being challenged, Lord, I would submit, Lord, that this case has a very different color and complexion, Lord, wherein I am not only on the point that the written submissions were not considered or a fast tag report was not considered, but there is, Lordship, in the whole perspective, Lord, on examination of the e-way bill system, Lord, in respect of transshipments and use of a second vehicle, Lord, there, the whole computer system, Lord, I had the occasion to be examined. I had occasion to examine yesterday, Lord, and I find, though I have made a specific government in paragraph 10, Lord, of my petition. Lord, in paragraph 10 of my petition, if my lords will kindly have the pleasure.
what was the ground? What was the ground?
The ground was that the transshipped vehicle said to be transshipped, Lord, was not carrying a way bill of its own number, and therefore, and it was present in Bihar, and whereas the transshipment was in between Kanpur, Lord, to the state of West Bengal, Ulkipara, Lord. Now, Lord, based on the facts, Lordship,
Not have the e-way bill at all.
no, I had it, Lordship. That is what precisely I had to submit, Lord. That, Lordship, the consigner generated the way bill, Lord. I was carrying it from Kanpur, Lord. There was a Kumbh Mela, Lord, the world knows. And then in Kumbh Mela, I have got stuck up, Lord. I have reached Azamgarh, Lord. And at Azamgarh, the vehicle has developed a technical snag, Lord, beyond repairs. So therefore, I had my own transport vehicle, Lord. I am a transporter from the state of UP.
So what you did, you unloaded that,
Yes.
and you changed it without
Yes. What
modifying
was
the
happening-
e-way bill.
No. I was having it, Lord. That is what precisely I am to submit with humility, Lord, that I was having a way bill. Lordship, what has happened in the process? I may just explain in 1 minute, Lord, without referring to it, and then I'll refer to the papers if at all desired by my lords today. Lord,
No,
what
I am hearing
submit-
you today only.
Lordship, grateful. I am so
Yes.
grateful. I am so grateful. What has happened, Lordship, that when I have reached Azamgarh, the vehicle has developed a technical snag. And then I, being a transporter, hired a other transporter, Lord, whose vehicle was on way from Bihar to UP, Lord. The owner has given a fast tag report of that vehicle also. That vehicle coming from Bihar, Lord, has reached the UP place of its destination, and from there it came to Azamgarh, Lord, on instruction of its owner. The fast tag report would show that, Lord. I am not to make an oral submission at all.
the fast tag report of that vehicle will show that in that case,
Lord,
Lord,
all on merits. Why will I interfere?
no, Lordship, that is what precisely.
Why will I interfere?
My lords will have to look into only one part of my aspect, apart from my written submission not being considered. I don't want only to be relegated, Lord.
On 29.
Yes.
You see, an order has been
Lordship.
passed. Bad order. Is it your case that the order is?
No, my case is very different now, Lord. Now, case before my lords is different from all other cases, Lord, which have been verified, have been considered all across by the Honorable High Courts, Lord, in the country, Lord. What I am submitting, Lord, that when I transship, Lord, when I have transshipped the vehicle or use a other vehicle, Lord, then I have to approach while extending a e-way bill, Lord. When I am extending a e-way bill, whether on expiry or transshipment or otherwise, Lord, then in that case, Lord, I have to approach the portal. Now, when I fill in the portal, Lord, there is a drop-down column that comes in. Why do you want to extend the bill? Then that would show different columns, Lord. Columns.
You are saying that there is no column for
Yes, Lord. No, there is a column. There is a column. It says transshipment. It says breakdown. It says others. Lordship, I examined. I had to do transshipment. I did others. Then after I tick one of these select columns in the drop-down, Lord, then there, Lord, is a drop box again to give reason. So I have to give a reason that my vehicle number so-and-so has broken down. Lordship, then I have genuinely and bona fidely believed that I have generated a way bill. On that basis, I have further transported in the transshipped vehicle. Now the intercepting authority, Lord, what he finds that I am not carrying a way bill of that vehicle number, because what happened, Lord, I put the number of the transshipped vehicle, and when it came to be printed out, Lord, then in that case, what happens? The old vehicle number is there. So he says you have a defective thing. Now, Lord, I have taken up.
When did you realize that?
No. It is the intercepting authority. Lordship, what I am finding.
Realize that.
No. I generated a way bill. When I generated a way bill,
you did not realize this.
On extension of the way bill itself, I realized it, Lord. That I was genuinely thinking that I am carrying a proper way bill. So the driver was instructed and he was gone. He forwarded. Now the intercepting vehicle. Lordship, I am stating a technical problem that I am facing. Or anybody else would face, Lord. What has happened? That after the drop-down box, Lord, when I give the reason, transshipped vehicle number so-and-so, due to breakdown, unable to move further, then the reason, Lord, is not displayed to me. Though I am typing out on the portal, it is not displayed to me at all. What I get, that A and B part of the e-way bill, and not the part on which I have written the number with a reason. Now, Lord, what I submit for my Lord's consideration, the photo shots of the waybill system is there, which I placed before my Lord's, Lord. There, Lord, apart from the reason not being there, even if I give a reason transshipped, I agree, Lord, that I put a wrong column of others. But even if I put others also, then also the vehicle number does not get displayed. Then also the vehicle number does not get displayed. Therefore, Lord, on that ground, Lord, what I
understand what the gentleman said. See, he is saying that he has genuinely wanted to change it.
Transshipment.
Now there is a drop down menu. He ticked others instead of transshipment. Kiran, me have ticked.
A comedy of errors. It is not.
No, let's go a little.
That is what we are on.
Test it.
No e-way bill.
Yes.
Let's test it out. Test it out. There are reasons columns. He says the reasons columns are not available for him. It will be available for you.
Yes.
Available, but at the time of printout, it's not.
It's not available for me after I upload it.
Let him take the steps.
It will be available for you. Just bring that document. If you can. On the next date, he has come. Let him be satisfied That was there.
Lordship, I will give a copy
That
to
will
my
come.
learned friend also.
How would you give a copy? Because you don't have.
No,
You
no,
have retained,
the
you have retained the screenshot of that document.
Lordship, the
And you
demo
are
can
not
be-
aware then that
Lordship,
this was generated in respect of a different bill.
Right.
You were so careful at that
no,
stage.
the
written a-
bill number, the quantity, the value of the goods are all same, Lord. These are
Yes, yes, it
excitable
has
goods.
to be, because the goods, my lord, if your lordship looks at
No,
my
that is a
adjudication
different,
order,
I understand.
It's a demo version, Lord. My Lord will
No, no,
kindly
no,
have
that
the
is a-
pleasure to look into
Mr.
this.
Siddiqui, can you bring it tomorrow? He'll be, gentleman will he'll be here.
tomorrow, my lord, take it high.
But you will be having that. Otherwise,
I'm
what
not,
will-
my lord, I have to take instructions.
otherwise, why will be the reasons be there?
I have to
Yes.
take instructions. My lord, but still, my lord, if on merits of the case, if I'm supposed to,
Not required.
Not
Merits on the case not required, because if we can overcome this, then you see, there is a threshold. Threshold is, you see, there is an appeal provision. Now, say as a
not only appeal provision, if your lordship looks at the
provisional
adjudication
release,
order
there
in the
so many
section
things are there.
129(3), my lord. Your lordship, we have taken into consideration also the route of the vehicle, that mapping, geomapping, everything. We
I
have
will
said
not,
the
I will not
same-
go anywhere.
We have said, my lord, specifically in our adjudication order, the same goods, my lord, the same quantity of goods with different tax invoices, my lord, but they were being recycled. We have specifically said.
They
was
have
a
said
different-
it without
this
evidence,
was
Lord.
a
I have
different-
submit.
My adjudication order. This is, my lord, we said that you have used one vehicle for one transshipment. We have specifically said that. And the same specification, with the same specification, they have been trying to take advantage of that specification. That we have the tax invoices with regard to this vehicle, we are doing this.
Tomorrow morning,
And
you
we
will
have
be back when?
specifically said.
Tomorrow you will be here morning.
Lordship, if my lordship's direct, Lord,
Can you
may
take
I,
instructions?
Lord, may I in the
What
time
time?
being, Lord?
No, tomorrow morning means tomorrow at 2.
Yes, yes.
Because tomorrow we get a, otherwise he'll be back again, he'll be coming back.
Because, my lord, I'm not quite sure with regard to this, my lord, whether they will be retaining.
I
or the
just
gist-
record instruction,
yeah,
nothing
or
more.
the
Lordship,
gist
it's
of
all
it.
on the portal.
Ah.
It's all on the portal.
on
It cannot get deleted, Lord. Lord, for demo version, my Lord, my learned friend may also, Lord.
আচ্ছা, I just, yes, এই কালকে ওই মামলা কখন আছে? The fixed matter.
I have fixed a matter at 2 p.m. tomorrow. my lord.
2 p.m.
Different.
Very well, you take instructions in the matter.
I'll come back in the morning tomorrow.
ওইগুলো 17
বারোটার সময় রেখে দিই।
অরিজিনাল সাইডে জিজ্ঞেস করো।
But if we have but tomorrow 2 p.m. I'll have to serve. I'm subject to correction. But I have a matter fixed before another court.
So where will you?
Lordship,
even
I
Mr.
come from
Chakraborty, that's-
Patna, Lordship. I come from Patna. Lord, if my learned friend is in difficulty tomorrow, I'll come the other day, Lord. There is no difficulty. But what I wish to bring to my Lord's notice,
I'll hear,
Lord,
let them take
that my
instructions.
Lords will consider. My Lords will only consider this, Lord, and nothing beyond. My Lord will see. This is a practical problem that would coming, Lord, and my Lord would be the first to consider it in the country, Lord. Lord, this is the
You see, you are
computer
today,
generated
you are today
invoice.
challenging 123(3), which is directly appealable. Why will this?
No, the appellate authority, Lord, cannot rectify this, Lord. It is the GSTIN then will have to be added as a party by my Lord's permission, Lord. My Lord will consider this will have wide ramification, Lord. I may submit with humility to my Lord's, Lord. Lord, the portal does not submit. It is a technical glitch, Lord. This requires improvement. And if at all my Lord is satisfied on the submissions which I am to advance before my Lord's, Lord, then my Lords may give appropriate directions, Lord. Lordship, I am not here to canvass, Lord, only on the matter of the penalty, Lord, at all. I am on the issue, Lord, that apart from non-consideration, other issues that are available to me, natural justice, Lord, it is the portal which suffers a glitches, Lord. And even if I put the right column, Lord, the
Where are
vehicle
the
number does
statements
not
made in
come.
the petition? Where are your statements in support of what you are saying in the petition?
Yes, Lord, in paragraph 10.
Yes.
Yes. My Lord, I will just permit it to read it, Lord.
Yes.
Page 6, Lord. That the petitioner states that since the e-way bill was getting expired by a flux of time on 20th of February 2025, the same was extended until 24th of February 2025. The petitioner states that as per the provisions of the Act, the way bill had to be extended 8 hours before the expiry of the way bill. The petitioner, acting in accordance with the said provision, extended the e-way bill online on 20th of February 2025 until 24th of February 2025. The petitioner states that while extending the e-way bill, it had filled in the number of the other transport vehicle, namely UP 76Y17 on the portal. The petitioner states that the e-way bill was automatically uploaded. However, while taking a printout of the e-way bill, it was noticed that the detail of the transport vehicle, namely 6157, this vehicle, Lord, in which the goods were transshipped, did not find mention, and the same only carried the number of the earlier transport vehicle 5955. The same only showed extended in the column of the validity. The petitioner, in the belief that the details of the transshipped vehicles were already uploaded on the basis of the extended way bill, proceeded to move further. That the aforesaid vehicle was intercepted by the respondent number.
Prabhat Kumar
Yes, Lord.
was there. He had downloaded this. Prabhat Kumar had downloaded the e-way bill.
The other person, Prabhat Kumar, has affirmed the affidavit, Lord.
Yes. He has said it is true to knowledge.
My Lord will
Yes.
find.
Affidavit portion.
Yes, yes.
His knowledge.
His knowledge that this is the fact, Lord. That is why I was.
Knowledge or information derived from someone else.
It is an information, Lord. Of course, it is a.
Then why will I
information from the
accept it?
portal.
It is information derived from someone else unless he has personally downloaded. He is a power of attorney holder. If he is not even the petitioner.
He might have uploaded it, downloaded it. Not.
Where is your statement to that effect? Where is your statement to that effect? You are, sir, paragraph 10, you are saying facts, detailed facts. Person who has personally done it can say he is only a power of attorney holder.
Is when
Authorized by the petitioner.
Time, Lord.
What is only signature? How can he say that he has personal information on this?
Lord. What he has said that he has knowledge.
Yes.
Yes. Then he must have knowledge, Lord. He's there outside, Lord. Can I take instruction in a minute?
You
Lord?
take instructions from him.
Just ask him.
Did he download? How will he have? He's a power of attorney holder.
Ask him.
You say that it was automatically uploaded.
Lordship, that is how the portal works, Lord. That
Very
is
well.
why, Lord, that
Very
is what
well.
precisely.
So someone has to download it from the portal.
Yes, Lord. That is why the printout was taken and the hard copy was being given to the.
So who has taken the printout? He has taken the printout.
He might have taken the printout.
Let us see. Where is his statement to that effect? He has taken the printout.
He has taken a printout, Lord. Normally, we do not state in the petition, Lord. But
No,
if my Lord,
not
Lord,
of- no, no, sir,
precisely, I would submit,
not of
Lord.
this nature,
I would
because-
submit a supplementary
because-
affidavit to that
Yes,
effect,
yes,
Lord.
you have to in
Yes,
this
I
case.
do that,
The
Lord.
person who has taken down, because this is a very serious thing.
Lordship,
You are today alleging the portal is not
Lordship,
generating
Lordship,
something else.
Lord-
And it has not occurred with others. You are the first one to
Lordship,
allege this. No,
Lordship,
naturally, I'll take it whatever. you
Lordship,
say. So
Lordship.
since you say so, you must be clear, specific, and up to the last point, should be in a position to indicate that this has happened.
Lordship, I would come with my computer system on the next
Not
date,
system
Lord,
will be not
and I would
necessary.
show to my Lord's Lord.
No, system, because the
Lordship,
facts
as your
are,
Lordship pleases, Lordship.
the printout was noticed. Who noticed? When?
He noticed
When?
on the date was taken up.
When it was taken up? When?
Lordship,
Where are those? Who will fill in the blanks now?
Lordship,
Lacunas
Lordship,
cannot
by
be permitted
a
to be filled up by a supplementary affidavit, sir. Your lacuna in pleadings cannot be permitted to filled up. Today you did not indicate. You say, however, taking a printout of the e-mail bill, it was noticed that details of the transport vehicle, namely such and such in the goods,
Yes.
did not find mention. When it was detected, who detected? Who filled up, first of all? Who filled up this particular extension of the transshipment of the e-bill? Who filled up that? Was this gentleman Prabhat Kumar did he fill it up?
Lordship, it
How
may
he
not
has,
be- it
how
may
can
be-
he affirm an affidavit and say that this number was uploaded on was attempted to be uploaded on the portal? These are very serious issues.
Lordship, my learned friend can make an inquiry.
How
It's all on
that
the
is a
portal,
different issue.
Lordship. Lordship, it can
No,
be
first of
inquired
all,
on
you
the portal,
discharge your
Lordship.
responsibility. You say you make a very serious allegation. Therefore, someone
No,
responsible.
no, Lordship, I'm not making an allegation. Lordship, to be very
Naturally, with on
precise
the
and
portal,
clear, Lord.
on the portal,
Yeah, Lordship, what I'm trying to bring to my Lord's notice, Lord,
Sir, you
that
have to-
the portal is having that anomaly, Lord, or a defect, Lord, out.
so where is the statement
Lordship,
to support you?
My Lords,
Where is the statement to support you? Sir, you are Mr. You are Mr.
I am DV Patim, Lord.
Mr. Bhatti, kindly understand. You say today that the portal did not give a correct output of the input given by you. Correct?
Lordship,
Correct. That is what I can understand.
Lordship,
Who had given that input?
Lordship,
Is
I
Prabhat
filed
Kumar
it-
put
I
in that
input-
input?
I filed.
Prabhat
Lordship,
Kumar
there
put
is
in
a
that input.
specific person who is doing it for all India, Lord. I'm an all India transport operator,
So
Lord.
who is doing that?
There is one Dipendra Kumar. Lord.
So
I will present
Prabhat
him
Kumar
on the
did
next
not do
date.
this. But the affidavit on the contrary says that this is all true to his knowledge. How does he have knowledge? Why was the name of Dipendra Kumar not included here?
Lordship,
Understand.
because these are centralized things, Lord.
That is more, all the more
Yes.
necessary. And how, and has this ever occurred to you in any other matter? Or
Lordship,
this is the
in
first
other
time?
matters, the same thing has happened, Lord.
And why
But
have you
then
not
they have
taken
not,
instances?
I have all never ever been penalized for this action.
So that
Lordship,
is a
I only beseech my Lord's indulgence, Lord. I only beseech my Lord's indulgence that vehicles which are running for thousands of kilometers, Lord, may
It's not
suffer
so
technical
simple. This
lapses,
is not
Lord.
so simple.
Lordship,
If you have breached this, Supreme Court has said that you have to comply with it. And you are 123, 129,
yes.
1 and 3 order is there. You, what about the goods? What are the goods that is there?
Lordship, these are pan masalas, Lord.
Pan masala. Have you asked for provisional release of this?
No, Lord. I have assailed the order before my Lord's, Lord, in a writ.
So you are not interested to take it out for the time being.
No, it's not that, Lord. What I am trying to submit, Lord, that if at all that case was made out, Lord,
If I
then had
also
not
admit this
deliberate
matter,
defaulted at all.
if I also admit this matter, I will put you to terms. Be conscious of that.
Lordship.
So it is not that ordinary
Lordship,
it is admitted.
Lordship, what I am
And
trying, Lord,
terms are value of on the value of the goods. Because why will I unnecessarily entertain a matter? But anyway, you take instructions on this. Notwithstanding his serious defects in pleadings, there are serious defects, but he raises a very serious issue.
Lordship,
Absolutely, absolutely.
Making some entry in the portal and that goes somewhere else.
No, not
But
go
he
somewhere
says
else.
that
He
the
says
change
that the
vehicle-
portal is not reflecting in the entries.
The change vehicle number is not being incorporated in that particular portal. The same old vehicle number comes.
But-
That is what his submission is subject to correction.
But very interestingly, the reasons are others. Others. He does not say that it is transshipment.
in the remark column, it is there, Lord.
More interesting is the dates. On 20th February 2025, the email is specified. He is supposed to extend the email on 20th February 2025. He says that I have extended the email on 20th February 2025 till 24th of February 2025. Now, my lord, the same vehicle number, the old vehicle number is there. I intercept the vehicle on 23rd of February 2020. The review of the West Bengal. I intercept the vehicle on that particular day. It says
Different
I
vehicle.
had extended the e-way bill, but the present vehicle number has not been reflected, it's not reflected in that particular. So that is what his contention is subject to correction. For 3 days, he was oblivion of the fact that that vehicle number was not incorporated in the email, that extended email.
Lord, it shows extended, Lord. It shows extended.
Extended, but
And I can demonstrate, Lord.
Full vehicle number.
The old vehicle has been sent to the garage, Lord. A division bench of this honorable court, Lord, I had the occasion, Lord, during my stay to look into that. Considered the issue of sending the vehicle to a garage, Lord. And on that ground held that it was not a case where such a deterrent penalty was to be imposed. It is a division bench order of my Lord, the Honorable the Chief Justice, Lord, here. And Lord, I had the occasion to read that. Lord, what I am trying to submit, Lord, what I am trying to submit for my Lord's consideration. What I'm trying to submit for my Lord's consideration is a grave issue, Lord. I would demonstrate, Lord, on the laptop and system. And my Lords and my learned friend also, Lord, I would satisfy at the same time that if you put anything, it does not come in the reason, Lord. It doesn't come in the reason. Otherwise, Lord, the reason doesn't get reflected. It shows only
Input is not the output.
Lord,
The GSTIN, my lord, has to.
Why did you not challenge this earlier? You are aware of the situation.
Lordship may permit me to add GSTIN as a party respondent. Lord, let an affidavit be coming on from
No.
there also. And then in that case, it would happen, Lord.
I'm not admitting the petition, so question of affidavit does not arise.
My lord, that this is the one must. If it is not released as early as possible, my lord, this is going.
So that apart, Lord, that is a fact, Lord, that is with
Entirely up to
everything
him.
that is edible.
Why are you so concerned? It is for the petition. This is for the petitioner to take a course. No,
Lord, if
not
the
necessary.
reason doesn't come, Lord, if the reason
No,
doesn't
not
come,
necessary, not necessary.
Lord, if the reason doesn't come, Lord, that is what I beseechingly pray. Lord, if
No,
the
you
reason doesn't come, Lord,
you see, difficulty is there is no explanation. How can you improve upon this? There is no explanation
Lord,
as
in
to when you
paragraph 10,
detected.
Lord, I have elaborately dealt with the issue, Lord. And subject to my Lord's permission, Lord, I will file a supplementary affidavit, Lord, in a very different circumstance, Lord. And I would explain it, Lord.
No. Permitting you to file supplementary affidavit today at this stage in these facts may not be possible.
My Lord, page 43, my Lord,
Yes.
the e-way bill, my Lord will kindly see,
Yes, sure.
Lord. What happens, Lord?
Valid until extended, but the reason is not available. What is the reason?
My Lord will kindly have the pleasure, Lord.
Yes.
The way bill number is mentioned. The way bill date is mentioned, Lord. Generated by is mentioned. The generation is by the consigner itself, Lord. Valid from the date, Lord. Valid until 24th of February extended. Lord, it is in the same format, Lord, but it only comes with an extension, Lord. This gives a reason, Lord, a bona fide belief to me, Lord, that the way bill I am carrying, Lord, is extended up to the time, Lord. And then, Lord, it is there. The old vehicle I would show, Lord. If my Lord would bear with me for a minute, Lord, the FASTag report to satisfy the judicial conscience, Lord, what I would submit with right earnest, my Lord will kindly see that finding of the assessing authority, Lord, is that number one, the vehicle was in Bihar. My Lord will kindly see from the FASTag report in a minute, Lord. I would demonstrate to
So
my
where
Lord.
is the order? Where is the order?
Yes, the
129.
impugned order is annexure 10, Lord, at
Page
page
98.
98, Lord. The handwritten order, Lord, is from page 102. Others are only the format, Lord. If my Lords will kindly have the pleasure, Lord, to page 104. That is a finding, Lord, which is I submit, Lord, contrary to the material on record and is perverse, Lord. Where, Lord, I would submit, beseechingly submit, Lord, that Article 226 would come into play. 104. My Lord, the last paragraph, Lord, the intercepted vehicle, if my Lord would permit me to read it, Lord, the intercepted vehicle bearing number so-and-so was verified. E-way bill officer, e-way bill system found no active online e-way bill existent against the instant vehicle number so-and-so. in support of the consignment loaded the vehicle. The statement of the driver so and so was recorded. Upon inquiry, the driver of the said vehicle stated that due to the breakdown of the vehicle bearing registration number so and so as mentioned in so and tobacco vehicle number so and so, Azamgarh, Uttar Pradesh, and the same would be unloaded at Raiganj town, Uttar Pradesh, Dijnapur, West Bengal. As per the produced document as noted above, the goods are dispatched from Kanpur to Uttar Pradesh and are meant to be delivered at Raiganj, West Bengal. On examination of the produced documents and taking into account the verbal statement of the driver, Shri so and so, intercepting the movement was of the opinion, intercepting officer was of the opinion that the goods of the document further verification and hence manual order and physical verification so and so. In presence of Sri Uday Singh, driver vehicle, intercepted vehicle, the consignment loaded in the vehicle is physically verified and the findings are recorded in so and so. Now, my lord, what he finds at the bottom line of the paragraph. My lord, I'm sorry for what has come in between. Uska paragraph page kahan hai? Yes. My lord will find in clause D, my lord. In the yes, yes, lordship, I would read, lord. It was found upon verification of registration number UP so and so in e-way bill MIS no active e-way bill existent against the instant bill number so and so in support of the movement of consignment loaded in the said vehicle in the instant case. The documents as noted above produced by the driver of the vehicle number do not support the movement of goods loaded in the intercepted transport vehicle. The claim of the driver that the goods loaded in the instant vehicle was transshipped from vehicle number due to breakdown of the same appears to be unfounded. It doesn't know material as his breakdown if there is any provision to enter the vehicle number in the new existing bill. I have said it before the lordship there also. The transporter or the supplier of the goods up to date vehicle reasons and transport. It appears that by giving the reasons and the place of transshipment, it appears that the transporter or the supplier did not exercise the option, which proves that the instant goods have been transshipped from vehicle number so and so. In the instant case, the intercepted vehicle is carrying similar but different consignment of the Madhupan masala and MI tobacco as declared in the produced tax invoices and e-way bills by recycling such invoices and e-way bills to cover the movement of and transactions of similar consignment for more than one occasion to evade tax payment. In the instant case, no such transshipment of goods.
Anything else, sir?
Lordship, my lords will find the last line, lord. That is what I am trying to submit, lord. That the tag mapping e-way bill MIS system, the intercepted vehicle bearing number so and so was not present in Uttar Pradesh on such and such, but was found in Bihar between the Parsoni Khem and Toll Plaza East and Parsoni Khem Toll Plaza from such as 14-2 to 22-2. Therefore, the claim of the driver that the goods located in the vehicle was
Sufficient not to accept
Now,
the petition, sir.
Lordship, my lord will see that his finding that the goods was present in Bihar, lord, is absolutely contrary to the FASTag report, lord.
Yes.
My lord will see the FASTag report.
The
For a moment,
challenging,
lord.
no, I'm not. FASTag report, I will not go into.
Lord, that is the
Challenging-
vehicle all, the appellate authority will extend his hands to look into the GSTI and portal to that extent, my lord.
Why not?
That besides,
They have the power and competence to do so.
No,
Yes,
Lord.
call the original side matters, please.
obliged, lord. Grateful, my lord, for a patient hearing, lordship.
To mention.
Yes. All these.
Maybe be permitted, Lordship, jointly mentioning the matter. This is, my lord, the ARCL matter. The enforcement of the scheme of arrangement. Your Lordship had heard and concluded the hearing on April 2nd. We are only submitting the, my lord, written notes.
Lordship, get an liberty to file a 2-page notice.
Grateful, my lord.
Grateful, Your Lordship.
You know what I have I have Lordship's kind leave to mention a matter which was dealt with the Lordship in September. My Lord, Lordship had directed the additional registrar of assurances to disclose by way of an affidavit. This is matter with regard to 2 PAN numbers. Siddiqui was on the other side. My Lord, he was appearing for the income tax department, but the direction was on his my learned friend's client. I'll have a may it appear in the yes, Lordship.
Well, may I mention? Well, may I mention?
No, there was a direction upon him to file an affidavit, which he has not done.
Well, may I mention?
No, I have not. No. I'm not supposed to file No.
Well, may I mention 2 court applications for inclusion, my lord? But this may take some precedence, my lord. Every day damage charge I am suffering 30,000 rupees every day. Yes, my lord. But this is the first time it will be coming. Let it get precedence, my lord.
May I request? May I request to take up item 2 as the lead matter, my lord. Item. My lord, I had got it mentioned by my junior. My lord, the reason I have got it mentioned is, my lord, that, my lord, the issue in this petition, my lord, all these 5 petitions, the issue is similar, my lord. Now but that I cannot explain, my lord. We mentioned it for listing, my lord. I don't know why it is appearing. That I don't know, my lord.
एफिडेविट निकाले हैं क्या इसमें? नहीं, एप्लीकेशन निकाले हैं?
नहीं, कुछ That I cannot clarify, my lord, because I mentioned it. My lord, I mentioned it only to point out that the issue in all these 5 petitions stands clarified by the Ministry of Finance. That was the reason for mentioning. Now, why it is appearing in to be mentioned, my lord, how do I know? I only mentioned because all they were not. Yes, my lord. That is the reason I mentioned that, my lord, all these matters. My lord, may I just point out the issue in all these petitions?
The hearing, my lord, because this is a highly
Probably, my
technical
lord.
matter.
My lord, may I just point out the issue in, my lord, my lord, may I just point out? My lord, the issue involved in all this petition is that I am manufacturing AAC fly ash block AAC. AAC is a technology to manufacture the fly ash blocks. My lord, the only reason the proceeding was initiated and the orders were passed for all the 3 years is that AAC block is an article of cement. It is not a fly ash block. So, my lord, they initiated, my lord, kindly hear me, my lord, without, my lord, going into the, my lord. Yes. So, my lord, the issue is of classification. the department, my lord, they wrote a mail to BIS authorities, Bureau of Indian Standard. The authority concerned, my lord, they did not refer to the sample of my block. They initiated an investigation at my premises. Therein, my lord, there is a categorical, my lord, finding that there is a 65 to 70% of fly ash blocks, fly ash used as a material for manufacture of my material. My lord, there is a land given by CSC Limited, and there is a direction that I am entitled to set up my factory free of cost because I will be utilizing their fly ash to manufacture my blocks. And my lord, there is a notification by the government of India that if there is more than 50% use of fly ash block, it will be considered as a fly ash block. I am satisfying that condition. That is on the investigation. Now they write a letter to the Bureau of Standard asking them that whether the AAC, because I am using the two description in my invoices, fly ash as well as AAC. AAC denotes the technology used for manufacture of the blocks, and fly ash denotes the raw material. So they initiated an investigation that AAC blocks cannot be equated to fly ash blocks. And they write a letter to BIS authority saying that you please clarify whether AAC blocks and fly ash blocks are the one and same. The authority concerned rightly stated because AAC block can also be manufactured by use of sand. Because ultimately, my lord, to manufacture the bricks or the blocks, the ingredient to be used is silica, which is available in sand as well as in fly ash. So it can be used by both. So they initiated the proceeding. I wrote a letter to the BIS authorities asking them whether they have taken my sample or whether the clarification issued by the BIS is with respect to my product. BIS authorities categorically said that the answer given or the clarification given is not with respect to your product. No sample was obtained from you. So the clarification does not apply to me. Nevertheless, my lord, since this issue was there and that the initiation of this proceeding became a subject matter of concern for the entire industry. So the association for this manufacture of this AAC block, they wrote a representation to the finance ministry. They wrote a representation to the GST council. GST council had considered everything. Now the GST council, Ministry of Finance, on the basis of recommendation of the GST council, has come up with the clarification, my lord, that AAC blocks, if it contains more than 50% of the fly ash block, is a fly ash block and is correctly classifiable under the chapter heading in which I have classified it. So that is the short issue, my lord. I am just handing over this, my lord, the clarification issued by the Ministry of Finance, my lord, which has just recently come. That is the 40, my lord. The reason is that now, my lord, in my humble submission, my lord, the issue in the petition. Lower tax, right? It is chargeable to 12%, whereas, my lord, what they are seeking to classify is article of cement. My lord, I am used. But kindly refer to paragraph 4, my lord. Just it's a very small paragraph.
First of all, my lord, yes. No, it's a big point, not a very short point. Now, my lord, what is AAC? First, we have to. I put this question to myself. AAC is, my lord, autoclaved aerated concrete blocks. Autoclaved. This is a scientific term. Autoclaved, that is mixed. Aerated, my lord, it is being made porous. It is being made lighter by use of certain aluminium films. My lord, this is highly scientific. So, autoclaved aerated concrete blocks are known as AAC blocks. It is different from fly ash blocks, which only contains the fly ash from the thermal power station. Fly ash mixed with
without any binding agent, blocks
yes,
cannot
there
be
is
manufactured.
binding agent.
There has to be binding agent.
There is silica, there is binding agent. There has to be a binding agent.
Silica is not binding agent.
Yes, cement is the silica. My lord, but with regard to AAC blocks, my lord, AAC blocks are much lighter than, my lord, these fly ash blocks. Because AAC blocks, this is autoclaved aerated. The word aerated is made, my lord, used because it is porous. Now, my lord, My lord, no, this has come.
I want to correct my learned friend. We have one second.
2023 writ petition. Now he has come up with this. This has a no, that yes. Now he has come up with this. 2025. He could have very well given it to me earlier, so that I could have taken instruction with regard to this, because
paragraph 4,
4.3 is relevant. AC blocks containing more than 50% fly ash content will fall under HS 6815. What we have to find out whether this AC blocks contains more than 50%
that is
fly
what
ash.
is already verified by them. My lord, it is part of the order. It is part of their order that my has 65 to 70% of the fly ash. My lord, I will just show, my lord.
I'll come back to your lordship, my lord, because it is just being handed over to
just from the order, my lord, I will show.
No, but for this reason, my lord, it has come under the heading to be mentioned.
Page 368, my lord. It is the order, my lord. Page 368, where, my lord, they have, my lord, on their inspection, they have noted down the raw material content of my material. I am referring to 862, my lord, item 2. पहला वाला रिफंड क्या है? 1 महीने का है डिमांड से. नहीं, एक चीज नहीं है ना, मतलब वो उसमें ठीक से नहीं सोको जी सूट किया. 862, my lord, item 2 I am referring. Item 2.
1165.
इसमें देखिए ना, सेम ही आइडेंटिकल ही है. किसका आप रिपोर्ट है? ये 862. But they have, there is a inspection report. They have physically come to my premises. Kindly see, they have made a field visit, on the above that they have written to verify the exact nature of the goods which is in RTP's sole manufactured item. A field visit was conducted on 8/6/22 at the RTP's manufacturing unit at so and so. But just above that, page 368 only. Page 368. They have conducted a field visit. Obviously, I submitted, they must have verified it. They can verify. Correct. That is the only subject matter.
Lordship, may kindly allow me to come back, because my lord, there is a judgment of Honorable Supreme Court, passed by my lord, the then Honorable Chief Justice of India, that the recommendation of the GST Council is not mandated. I do not know whether.
My lord, with respect to rate of tax, my lord, I will just correct, my lord. I was part of that, my lord, Supreme Court, my lord, matter. No, I was there. No, my lord, my lord, I will just point out section 9, my lord, kindly refer to section 9, my lord. It is recorded in the judgment that with respect to some provision of the law, the GST Council recommended. One second. Section 9, just to address this particular aspect. Section 9, my lord, kindly refer to. Because this has been covered in that Mohit Minerals judgment, my lord. One second.
My good friend is a new entrant in this matter. Earlier, Mr. Mojumdar was up here, Mr. Obro Mojumdar. He's a new entrant. He's a new entrant.
No, earlier I was at the admission.
He's a new entrant.
How does that matter? I don't understand. That whether I am a new entrant or not new entrant.
But the only difficulty, my lord, he has come up with this.
Whether I am ready in this matter or not.
Taken out a supplementary.
But just section 9, my lord, I just want to point out. Subject to provision of subsection 2, there shall be levied a tax called the Central Goods and Services Tax on all intra-state supplies of goods or services or both, except on the supply of alcoholic liquor at such rates not exceeding 20% as may be notified by the government on the recommendation of the council. So with respect to section 9 rate of tax, clarified this, that with respect, my lord, that Mohit Manri's judgment I am not carrying because my lord, I may just
We'll come back on.
my lord, I am just point out, my lord, the 846, my lord, item 1 is with respect to refund. My lord, because it was a inverted tax. 1 second, sir. It was a refund inverted tax structure. So for March 20, refund was already granted, which they issued so-called notice, and then they sought to recover the
My lord,
and my lord, item 2, 3, 4 is for financial year 17, 18, 18, 19, 19, 20. No, it is for the entire year. The demand is there. Recovering
there is
the
an
differential rate of tax.
There is an adjudication order, my lord, in all this.
My lord, in 846, appellate order is there. No, my lord. All cases have the same issue, whether my item manufactured is fly ash block or not. That is the only issue. Whether I am manufacturing. Yes, my lord. No, refund arises, my lord. Refund arose because, my lord, my rate of tax is 12%. And my output tax is, input tax is 18%. So I was granted refund because, my lord, if there is an inverted tax structure where there is the rate of output tax is less than the input tax, then I am entitled to refund, which was granted to me. So thereafter, they issued so-called notice, recovered the refund amount, and the appellate order has also been passed in 846, my lord. 846 appellate order has been passed.
Speak any Latin, my lord. I was going to say the same thing. But all these matters is pertaining to the issue with regard to classification of AAC blocks.
Yes.
Whether be it an adjudication order or a refund application rejection order. Once it is classified as a fly ash blocks, everything will be covered.
My lords, lords, the issue in this case is squarely covered in the case by honorable division bench order in my own case for the previous period. Therefore, we mentioned it, my lords. So, and this item, along with item 43 in the today's list, my lords, both are identical issues, my lords, covered by the honorable division bench order. My lord, I am passing on the order.
Can I have a copy of the order?
Yes, my lords, the issue is, yeah, my lords, the issue in this case, yeah. My lord, the issue in this case is that, my lords, we are into the manufacturing of two products. One is fabric, other is bed sheet from that fabric. My lords, on both these products, the rate of duty is less than what I suffer on inputs. Therefore, my lords, there is an inverted duty structure in this case, and I am entitled for the refund. My lords, therefore, we applied for the refunds in both the matters. The issue in the case of fabrics decided in my favor by the department, no dispute on that. But issue in the case of bed sheets, the department holds that this is taxable at 12%, whereas I say that it is classified under chapter 63, which is taxable at 5%. Therefore, the department allows me lesser refund for bed sheets. One minute. My lords, para 24 onwards. Para 24 onwards, my lords, and it concludes at para 26, it concludes the issue. My lords, the revenue always argued that fabrics and bed sheets are one and the same thing, whereas those are two different things, different processes go into it. That is what is upheld by Honorable Division Bench. And directions have been passed to refund the matter. Yes. My lords, I'll take my lord. Yes, my lords. Para 24, that apart, the revenue never disputed the classification of PPSB bed sheets manufactured by the appellant under this HSN. In Collector of Excise versus Merit versus Capri International, Honorable Supreme Court held that cutting the cotton fabrics from running length into small pieces brings into existence new commodities like bed sheets, bedspreads, tablecloths, etc., which are definite commercial identity in the market. That apart, the cardinal rule is that burden of proof is on revenue when they raise the dispute regarding classification of the product. For this proposition, reference is made to this decision of Honorable Supreme Court in Garwade Nylons. Unfortunately, in the case on hand, revenue appears to have shifted the burden on the petitioner to prove the negative, which is not sustainable in law. Thus, for the above reason, we have a clear view that the learned single bench found the legal position is wholly in favor of the appellant. The necessity to remand the matter for fresh consideration would not arise. For the above reasons, the appeal are allowed. The order passed by the learned single bench to the extent remanding the matter to the appellate authority to reassess the facts is set aside, and consequently petitions are allowed as prayed for. And the orders passed by appellate authority, namely Senior Joint Commissioner, West Bengal State Tax, Calcutta, in both the matters are set aside. Refund applications stand allowed, and respondent are directed to effect the refund to the appellant within a period of 12 weeks from the date of receipt of served copy of the order. My lord, the issue in this case is identical. Even this petition number has been quoted in the impugned order. petition number जो है ना हमारा 28588, it is quoted in this order also, one clean order, page 231. My lords, page 231 of the petition, my lords. My lords, it records the petition number. It records this petition number also. Page 231, please, my lords. Page 231. Page 231 of the paper book, my lords. It records. It gives reference to this order, to this petition which was pending at that time. My lords, page 231, para 2, second para, my lords. May I read? The final date of personal hearing for the instant appeal case was fixed on this date. Shri Rohit Agarwal appeared on that date. Mr. Agarwal submits that arguments of appellate dealer has been mentioned in the details of the grounds of appeal. However, learned appellant further prays with a request to defer the hearing of GST appeal as he claims to have filed a writ petition number so and so. My lord, this is the same writ petition number which is there before my lords. I have submitted the final order. My lords, now please come to the findings. Findings are at next page, my lords, page 232. Classification of PPSB bed sheets. My lords, the last two orders on this page, page 232, last two orders. Classification of PPSB bed sheet. These are the same findings which have been decided by this honorable division bench in this matter, my lords.
So far as the order is concerned, my lord, I have to take instruction for once. Why? My lord, on two scores. First of all, classification dispute subject to correction, my lord. After this order of the department, it needs to be challenged in before the honorable apex court, my lord. That is what the statute says, my lord, exactly.
No.
And therefore, my lord, my lord, at least a week time be given, my lord. Still, if I may get off this, I have to go through the judgment also, my lord. And then if it is squarely covered, whatever it is, my lord, it is my lord, subject to correction. Classification disputes as per the statute directly refers to the honorable Supreme Court, my lord. That was the first, my lord, tape, my lord. Basically, it all on a sudden came up, my lord. I am also not, my lord. It is central excise.
This is GST case, my lord, not excise case. Excise. He is right in excise, not in GST.
Yes. But GST,
Excise
my lord,
matter,
there is
yes,
no,
GST matter.
apparently in all tax matters, my lord, it was supposed to be referred to the apex court, my lord. The classification was decided, my lord. I'll come back, my lord, with instructions. However, my lord, why I am saying, as already the division bench has decided on the issue, therefore there is no point in disputing that one. That I admit. That is, no, my lord, that is what I was just referring to. I cannot now.
My lords, this matter.
If it be Wednesday, my lord, sometime, because I cannot talk to the department also, my lord. In the meantime, my lord, tomorrow.
Rahul Tangri. My lords, this
Seven and eight. 7 and 8.
Obliged, my lord.
7 is the instruction and received from the drawing.
Stephen, I am for the press comment.
मैंने अलग अलग order. For the response. No, ma'am, there's no interim order. We are in for this. I'm grateful, Your Lordship. At which? That is to appear tomorrow, Your Lordship.